Okay, well, as people are continuing to make their way in, we're going to get started because we have a lot to talk about on this panel. And welcome. Thank you for being here. I'm Cliff Sloan. I'm a partner at Skadden here in D.C. I'm also on the board of the American Constitution Society. And this topic of corporations and the First Amendment is a very important issue, a very timely issue, one on which, as you know, there's a lot of lively discussion, very active topic in the Supreme Court and in other courts. And fortunately, we have a terrific panel to help us sort it out. And I'm just going to go down the line. I'm just going to give you brief highlights of their illustrious biographies. The complete biographies are in the program. And first, we have David Brodsky, who is a colleague of mine on the board of ACS, and David is a leading mediator and arbitrator. He was a top litigator for 40 years, representing both plaintiffs and defendants, and a former federal prosecutor. We have Charles Freed, professor at Harvard Law School.
And the faculty advisor to the Harvard FedSoc.
Okay. Thank you. Now we'll move along. A little feedback there. That was not in response. Charles also was a Solicitor General in the Reagan administration, and he's a former Associate Justice on the Supreme Judicial Court in Massachusetts. We have Elizabeth Wydra, who's a counsel with the Constitutional Accountability Center, very active in a wide range of constitutional issues in the Supreme Court and other courts, and recently was named by National Law Journal as the Appellate Lawyer of the Week, in a very interesting profile. Next to Elizabeth is Cherise Smith. Cherise is at the Federal Communications Commission. Until very recently, she was Chief Counsel to the Chairman. She's now a Senior Advisor to the Counsel's Office.
Yeah, for another 2 hours. Today's my last day.
And previously, Cherise was General Counsel of Washington Post Digital, the Washington Post company's online subsidiary, and I worked closely with her there. And interestingly, for purposes of this discussion, that's a company whose business is speech. So. And we have Bert Newborn, who's a professor at NYU Law School, who's a founding legal director of the Brennan Center, and among other things, is a former national legal director of the ACLU. So let me just say a couple of very brief introductory topics, and then comments, and then let's get the discussion kicked off. And first of all, when we're thinking about corporations and the First Amendment, it's worth just taking a moment to think about corporations and the Constitution.
On our panel, we originally had two people who were scheduled to.
The corporations and the Constitution. Prudence of the Supreme Court. Corporations have some constitutional rights, and there are some constitutional rights that they don't have. For example, we know corporations have First Amendment rights. They have due process rights. They have equal protection rights. Corporations do not have the right to vote, for example. They do not have a right against self-incrimination. So there are some areas where they have constitutional rights and some areas where they do not. And it is also worth thinking about in areas where they do have constitutional rights. Is that constitutional right different because of the nature of a corporation than if an individual was asserting the same constitutional right? So that's one sort of general question to think about. Now, on the panel today, we're going to think about corporations and the First Amendment. We're going to discuss it in three areas. And the first is corporations as political speakers. And there's a case you may have heard something about called Citizens United, which has made this a particularly prominent and pressing issue, and we're going to talk about that. The second area is where corporations assert the claim, sometimes successfully, sometimes not, that their speech or activities is protected speech under the First Amendment. So something that they're doing or they want to do is protected speech under the First Amendment, and a statute federal or state, or regulation which limits it is unconstitutional under the First Amendment. And the third area is when corporations are unwilling speakers, when there's a statute or regulation that compels a corporation to give certain kinds of messages, certain kinds of disclosures, and the corporation is very opposed to being the vehicle of that message, the conduit of that message. So we're going to talk about each of those. And just one last background point, you'll recall that, which may or may not come up with these points, may or may not be relevant to some of them, but you'll recall that under the current jurisprudence, commercial speech, pure commercial speech, advertising, proposing transactions, has First Amendment protection, but it has less First Amendment protection than other kinds of speech. So, with those introductory remarks, let's get right to the topics. And the first one is the corporation as political speakers. And I'm going to ask Charles to kick off that discussion. And we'll have a discussion. And by the way, I am going to try to save time at the end for questions and comments. Charles?
Citizens United was correctly decided. It was inevitable. It was inevitable because it has been a free speech principle ever since free speech was taken seriously, which was really only about 100 years ago or less, that government may not restrict speech, A, because of its content, with certain limits on the side, incitement to violence, so on, may not restrict speech because of its content, nor because of who the speaker is. And that's the idea that you want as much debate and as much information out there as people are willing to give. And that's been a principle which right-thinking, that is to say left-thinking people, have espoused in all sorts of connections. And here, you know, what's sauce for the goose? It just happened to come back to bite them. But it's the same principle. So why is it that there is such weeping and wailing and gnashing of teeth? And the reason is because Citizens United nestles under Buckley's independent expenditure expense. The corporations can't contribute to politicians. That's not been questioned, and that's not an issue. These are independent expenditures in terms of which the corporation is a speaker. Well, the independence may well be questioned, and politically, I'm afraid the Republicans have blocked every attempt to have really stringent rules enforcing the independence so that there isn't coordination by winks and nods, and disclosure. There again, Mitch McConnell has discovered First Amendment impediments to disclosure, even though the third act of Tony Kennedy's opera in Citizens United was a finale in terms of the glories of disclosure. So that's a huge piece of hypocrisy. And finally, it seems to me that corporations ought to be under the same regime as labor unions after Abood and communication workers against Beck. And a shareholder should be like a dues-paying union member. That is something that might be legislated by states which regulate corporations. And there, I think, the case is CTS, where the court waxed very eloquent about how how this is the job of the states to deal with internal corporate governance. Well, this is a matter of corporate governance, and my esteemed colleague Lucian Bebchuk has done very good work in this respect.
Okay, thank you. So let me ask Elizabeth now to comment on that. I know you've been active in this area and following it closely. Do you agree Citizens United was correctly decided? Long-standing?
No. You know, I think that, first of all, Justice Stevens' dissent in Citizens United was masterful, and I thought he did an excellent job of going through first, explaining how the majority jumped through and blew through numerous obstacles to actually getting to the radical result that they achieved in the majority opinion. But perhaps more important, he really laid out very effectively the history of how corporations have not been treated the same as individuals. And I'll talk more about that with respect to protected speech in particular, but they absolutely, when being dealt with as political actors, have never been considered to be the same as individuals. And Justice Stevens did a great job, I think, of pointing out that, you know, of course it matters who the speaker is to a certain extent. You know, children, they don't get the same First Amendment rights that adults do. Children in schools don't get the same First Amendment rights that adults out in the world get. The government can put greater restrictions on government employees than would apply in other contexts. So of course it matters, really, who the speaker is in certain contexts. And I think, you know, and additionally, if you're going to look at whether Citizens United was correctly decided, you have to look at what the majority said about the government's interest in preventing these sorts of corporate expenditures. And the majority did something really clever in terms of achieving sort of their vision of First Amendment law and campaign finance regulation, which is to say that the government only has a legitimate interest in corruption that is essentially quid pro quo. So that's sort of the bribery idea. But if you look back at the founding era, that's actually not what the Constitution's drafters were concerned about. I mean, obviously they were concerned about bribery, but it was much larger than that. Larry Lessig is working on some really great stuff that shows that when the founders talked about corruption in their debates over the Constitution, they were concerned about, you know, more than just quid pro quo bribery, but also this idea of improper dependence on outside forces. The government was intended to depend only upon the people, and by that I mean actual people, not pretend corporate people. And so they were concerned about improper dependence, so they created the checks and balances system, and they also envisioned that the government would have the ability to root out corruption writ large, which is sort of, as Larry Lessig puts it, this improper dependence argument. So I think that there's a lot wrong about the majority's opinion in Citizens United, and I think those are just two aspects of it.
Okay. Bert, you want to jump in here?
Charles didn't reveal in his biography that he's a staunch ACLU volunteer attorney who has argued many First Amendment cases for us on a principled basis. And I respect his approach to Citizens United. I agree that it was inevitable, but it was wrong. Wrong, I think, at a very deep level. I agree with Charles that the real problem in American electoral life now is not Citizens United, it's Buckley. Buckley sets us off on a tangent where wealthy people can essentially dominate the electoral process in ways that I don't think the founders would have dreamed was the democracy that they were working on. But Citizens United makes it worse, and it makes it worse through a thought process that is very dangerous and that it's creeping into American jurisprudence everywhere. And that's a renaissance of the old 19th century idea of corporations as sentient beings, as though they were actual things that walked the earth and had rights in their own right. rather than simply being abstractions, labels that we have chosen to put on collections of individuals because we hope to achieve certain ends by essentially allowing those individuals to use the corporation as a central enforcement arm for what are shared collective rights in the corporate community. Now, Citizens United brought that, I think, to a kind of its sad ultimate end, which is to treat the corporation as though the corporation were a speaker with a sentient soul, a Kantian being. I mean, you can imagine Kant spinning in his grave over the idea that corporations are Kantian beings. I wrote a piece for The Nation some years ago, which will be bleeped out of this conversation, but I said if things keep going the way they are going, with the way we are treating corporations jurisprudentially in American life, if you're lucky, you're going to be able to be adopted by one soon. If you don't get adopted by one, maybe you'll be able to marry one. Until then, you just better get used to being fucked by them.
And here comes the FCC.
Now, I use that indecent word on purpose, the same way that Mel Nimmer used it brilliantly in the Supreme Court when he argued Cohn versus California back in '71. I was
otherwise known as the fuck the draft.
the fuck the draft case. I was the second chair in that case, and we had a long discussion about whether he would use the word in the Supreme Court, and it almost killed Warren Burger. But I use it on purpose because only biological entities can fuck. And we have begun to think about corporations as though they are biological entities. And so when Apple metastasizes its corporations all over the world to avoid taxes, we treat them as though they were simple individuals, lots of little individuals that were cloned by Apple that all have individual rights, and if you move the pie around quickly enough between and among the individuals, you defeat the regulatory power of virtually any nation state. Now, we're on the verge of that in a world in which the most powerful entities that we face are transnational corporations with the capability of vetoing the regulatory power of virtually every nation state in the world except perhaps the United States and China. And one of the ways they do it is by pretending that corporations are things, and that as things, they get us to reason from the existence of the thing. John Dewey called it transcendental nonsense. He was right in the 1930s, and he's right now. We really have, it isn't just Citizens United. It's that we have to remember that corporations are a metaphor. They're a metaphor for a collective group of individuals upon whom we bestow certain pre-established contractual rights. And then they operate in a way that, by and large, benefits the mankind immensely. It's one of the great forces for the accumulation of wealth that has ever been achieved. And it's great for that, but it's also tremendous accumulations of power. And unless we remember that they are not things, they are just things that we have made up, we're going to be in trouble not just with Citizens United, but across the entire regulatory board.
Well, the trouble with Bert's account, which I found ripping, is that it's exactly one half of the free speech value. The free speech value, or if you like, the inhibition on government regulation of free speech, says you can't close down speech because of the speaker, not for the sake of the speaker alone, but for the sake of the listener. And so what Bert's argument would do is deprive the public of whatever it is the corporation wants to say, and therefore of speech And that is a very strong First Amendment value. And that's what, and that is what Bert's account leaves out of account. Now, nestling in that account is the notion, yes, but they talk so loud and they talk so much and it drowns out other speakers. Well, talk about metaphors. Corporate speech doesn't literally drown out others. It's maybe more graphic, maybe more interesting, maybe more compelling, maybe more amusing. All grounds which the government is not entitled to take into account in suppressing speech.
Well, I don't want to monopolize it, but I think Tamara Piety is in the audience, isn't she? She's got a book where she calls Charles's approach tough love. Tough love for hearers. 90% of the American public doesn't want to be bombarded with enormous amounts of corporate speech generated on a short-term profit basis in ways that may not drown out other speech, but in particular elections can dominate it and can allow huge aggregations of capital to be brought to bear on political issues that dwarf the ability of ordinary people to participate. Most American hearers don't want to be subjected to that kind of barrage. They would like a world in which they had maybe one or two less instances of a corporation repeating its slick political ad each day, and maybe hearing from somebody else who doesn't necessarily have those resources. And I don't think the First Amendment says that that what a speaker like a corporation, which doesn't have a soul, borrows the soul of the hearer and says, oh, well, this is good for your soul because the First Amendment says you have to sit here and take whatever we give you. And who's asking the hearer? In most of the cases that developed hearers' rights, the plaintiffs were hearers who wanted to receive the information. What's different about Citizens United is that it uses hearers as a springboard to empower corporations, but nobody asks the hearers. And the truth is, the hearers don't want it. That's why Citizens United is the most unpopular case in the country. It's because we know that it's bombarding us with stuff that we don't want to hear, and we don't know how to shut it off. Now, Charles is right that we've got to be very careful that you don't throw the baby out with the bathwater. You don't want to have one counterreaction that eliminates the ability of corporations to function effectively as economic units. So the idea that you take their constitutional rights away completely, I think, is wrong. And we don't want to have a First Amendment reaction that seriously weakens the doctrine. But I think we could remedy Buckley and Citizens United tomorrow with one more vote in a way that would reinforce the First Amendment and not harm it. And I think that's where progressives like ACS should be aiming for.
Let me just ask you one question on that, Bert, though, because normally in the First Amendment context, the idea that you can shut down speech because a lot of people don't want to hear the speech not only is not a sufficient reason, it's an alarm bell.
Yeah.
So why do you think it's different here?
Well, because I think that speech, the First Amendment is contextual. It operates in different contexts. So, for example, in a legislature, you can shut down speech if someone has spoken so long, everywhere except the Senate, that it is preventing the business of the legislature from going forward. So the hearers can say, enough, you've spoken enough. You can say enough in a courtroom. You can say enough in a classroom. I think an election is a kind of bounded institution where you can say enough there as well. If you have a situation where you don't have a speaker with First Amendment rights, and corporations, even under Citizens United, the court never went so far as to say the corporation is being protected They always said it's because the hearers want the information. The corporation itself is not a protected speaker and never has been recognized as one. It's always derivative of the hearer's rights. Now, when you have most situations, the speaker has a right and the hearer can't shut it down. But where the only right in the game is a hearer's right, surely the hearer's desires should be taken into account before the First Amendment door closes.
Yeah, I just want to say a quick thing. I think that Citizens United is so extraordinarily unpopular because the American people intuitively are offended by the idea that their political speech is equivalent to corporate speech. And I think that's because of the unique nature of the corporation that's given all of these state-granted benefits to amass wealth for, the good purpose of economic growth and development. But when they use those in the political context, the American people don't have to be lawyers to know that that doesn't make any sense. And, hey, maybe I'd be more okay with Citizens United if I got to have perpetual life and limited liability. But until Justice Kennedy can give me that.
Okay. Well, as I mentioned, we have a lot of topics, and I'm going to move on to the next one. So this is the second category that I mentioned at the outset, when corporations are making a claim of protected speech. And we're going to talk about a few different areas, a few different litigation contexts. And the first one is a very interesting and important Supreme Court decision from the last few years that actually probably has not gotten as much attention as it should, the Sorrell decision. And I'm going to ask Elizabeth to kick off that discussion.
Yeah, so the Sorrell case is a really interesting case about commercial speech that had to do with Vermont law that was about data mining companies so Vermont required pharmacists to retain information about what doctors were prescribing, what sort of drugs, and they prohibited pharmaceutical manufacturers and data mining companies using this to essentially help pharma companies to target doctors to say, either to reward the ones who were prescribing their expensive prescription drugs or to target the ones who weren't doing it enough, try to get them to. The Vermont legislature essentially felt that these regulations were necessary to protect privacy, to protect health and safety in numerous ways by protecting the doctor-patient relationship, to prevent doctors from feeling harassed. I know that even while I've been waiting in the doctor's room, you always see these drug reps coming in. I would be like, hello, I've been waiting 45 minutes already. So the Vermont legislature created a record and decided that this was in the best interest of their citizens. The Supreme Court, in a 6-3 decision, struck down that law as being in violation of the First Amendment. And what was really remarkable was not just the decision, but the way that the majority, in an opinion by Justice Kennedy, equated the speech rights of corporations and individuals with respect to corporate speech, saying that these speaker-based, content-based restrictions applied just as strongly to commercial speech as they would to, say, political debate. And that's really a remarkable departure from court precedent as well as text and history going back to the founding. Sort of the idea that Bert talked about of corporations as being these artificial entities was certainly the way that the founders thought about corporations. James Madison and Chief Justice Marshall talked about corporations as being these unique artificial beings that were state-created through their state charters and were distinct from we the people, by and for whom the government was created, who were endowed with inalienable rights, not just the rights that were granted to them by the state and their corporate charter. And with respect to the First Amendment, commercial speech was always given some form of protection, as Cliff mentioned earlier, but it was given much less protection than an individual speech. The iconic idea of individuals speaking about the government, political debate. While some commercial speech was, of course, recognized by the court to have informational value, so it could be relevant to this marketplace of ideas that we always invoke talking about the First Amendment, the state also had a substantial interest in regulating commercial speech, and even more broadly, corporate activity, in the interests of the public. And at the founding, this was a given that states had substantial authority to regulate corporate conduct. A lower standard of scrutiny was understood by the court when dealing with commercial speech to allow states like Vermont to balance their traditional powers to protect public health and safety with whatever benefits there were to commercial speech, and of course, corporations' ability to conduct their affairs. So while corporate commercial speech in general got a lower level of First Amendment protection, there was even a lower level of protection given to misleading, deceptive, or aggressive commercial practices. I don't know if we're going to talk about that later, but there's also challenges going on these days to like Standard & Poor's ratings, which I would think would fall under that, but they're saying, oh no, we get First Amendment protection even if those ratings were perhaps misleading or wrong. But important for the Sorrell case, which Justice Breyer pointed out in his really well-crafted dissent, was that when it came to just regular economic regulation, the court essentially gave very low scrutiny to claims that such regulation violated the First Amendment, even if that economic regulation affected speech. And the court would defer significantly to the legislature's decision. And as Justice Breyer noted in his dissent, to apply the heightened standard of scrutiny that the Sorrell majority applied to Vermont's economic regulation of this sort of prescription data is to transfer from the legislatures to the courts the decisions about how to weigh the legitimate ends that states are concerned about in protecting public health and safety, and the means of reaching them. So we had the majority in Sorrell second-guessing whether Vermont had good reasons for doing this, whether they could have written their regulations any better. And that sort of gets us back to, the Lochner era, where it was common practice for the court to strike down economic regulations adopted by state legislatures and to substitute their own notions of the most appropriate means for the state to implement its desired practices. And so Sorrell hasn't gotten a lot of attention, but I think when you put it with a lot of these other cases that are coming down the pike with respect to challenges to labeling on tobacco, which has been struck down by the DC Circuit, to other corporate challenges, to even disclosure laws. We say under Citizens United, oh, okay, at least we have disclosure laws, but some corporations have been challenging those as compelled speech. So, I think once you start having the courts being the ones to decide how you go about regulating corporations and what are sufficient economic regulations according to its own economic theory, then you are really, as Justice Breyer said in his Sorrell dissent, threatening return to the Lochner era. And I know that the first 2 decades of the 20th century have been very trendy lately with Downton Abbey and The Great Gatsby, but I am not looking forward to the Roberts Court remake of the Lochner era, and I'm not just saying that because it stars Anthony Kennedy and not Leo DiCaprio.
I'm going to open it up to the panel in a second. A couple of the cases that Elizabeth mentioned, the credit rating agency case and the tobacco case, we're going to talk about in greater depth. But I do just want to point out that, as Elizabeth mentioned, it was a 6-3 decision. I think it was Justice Sotomayor,
Yeah.
right? So this was not a 5-4 ideological split. At least one of the 4 was with the 5 on that. But now
It was still wrong, though.
I don't know if anybody else noticed, but I noticed that Elizabeth was eliding 2 things. She talked about commercial, she talked about corporate. What you have to notice is this is a case about commercial speech. It's not about corporate speech. The same thing would be.
Some people would say it's not even about speech; it's about the use
Well,
of data.
that's what you say. But whatever it's about commercial speech or non-speech. It's not corporate. if somehow the drug companies were not corporations, the same exact arguments would apply.
But that's what I
the-
think is remarkable.
And the next point is, your beef is really with the commercial speech doctrine. And you're saying commercial speech is a return to Lochner. May I point out that that return was announced in 1976 by that great Lochnerian Harry Blackman, and your point, almost in ipsissimis verbis, was made by that great ACS member, Chief Justice William Rehnquist. Your point is Rehnquistian, and
And Rehnquist was quoting Chief Justice Marshall when he talks about the dangers of corporations and the need to regulate
but
corporations more than individuals.
More recently,
And I'm totally cool with Chief Justice Marshall.
More recently, your point in the commercial speech area, whether it's by a corporation or an individual, was exactly what Rehnquist said, and the court rejected it. Harry Blackman rejected it. William Brennan rejected it.
I think maybe we're talking about a couple of different things, because I think if you look at Justice Breyer's dissent in the Sorrell case, he is noting that in the commercial speech doctrine, the majority is departing substantially from commercial speech doctrine, even prior. I mean, I don't have a problem with commercial speech doctrine prior to Sorrell. I think that what Justice Breyer is saying is that the Sorrell majority is making quite a substantial departure from existing commercial speech doctrine by equating the speaker and content-based restrictions that states often use on commercial speech with speaker and content-based restrictions that have been used on individual speech.
Anybody else on the panel?
Can I? I'm going to speak up for Justice Sotomayor. I think she was right. I think Sorrell is rightly decided. I don't think it's a wrongly decided case. There's an interesting parallel, and it's a parallel that I haven't seen drawn between the old cross-burning cases, RAV and Virginia versus Black, where the first case, RAV, they struck down a cross-burning conviction on the ground that the statute was being used in a discriminatory way to deal with one viewpoint, but it would not have been used if the same behavior had been used with a different viewpoint. And people were shocked by that because it was the first time that this discrimination reasoning had been used to deal with what had been a categorical exception from the First Amendment. Scalia found in RAV that this was fighting words, that it was a categorical exception to the First Amendment, but that even categorical exceptions to the First Amendment could not be discriminatorily applied on a viewpoint basis. Interestingly enough, Sorrell, there's a direct line for that to Sorrell, because in Sorrell, this statutory scheme that the Vermont legislature came up with applied only to a narrow category of marketing that Big Pharma used. Now, I'm as offended by that as Elizabeth is, but it left open, for example, the ability of academic researchers to get full access to this information with no limits at all. And so it was the Vermont legislature making judgments about which speakers could use this information and which speakers could not. And once you start making those distinctions within categories of speech, even if it's as unprotected as fighting words, I think it's right for the Supreme Court to step in and say, no, if this is so important as a privacy issue, then academics don't have to know what the doctors are prescribing either. It isn't just big pharmacy companies who are threats to privacy, it's any information. So if you're going to do this, do it right and do it for everybody. Don't just pick out one particular group. And so my sense is, I think Sorrell may well, Elizabeth's right, it may well be overread as a case in which the Supreme Court is moving toward a much more muscular commercial speech doctrine that essentially eliminates, if it doesn't eliminate, it compresses the difference between political and commercial speech. I doubt that's going to happen. I think it's worth worrying about, but I don't think Sorrell, read correctly, stands for that proposition. I think that the existing commercial speech doctrine that Elizabeth says she has no problem with and that I don't have a problem with, I think it remains intact after Sorrell.
I hope you're right.
Okay. Any other comments before we move on to our next topic? Okay. Well, Elizabeth mentioned the litigation involving the credit rating agencies, and let me ask David to kick off that discussion.
Thank you, Cliff. My preliminary observation is that I have no idea why I'm on this panel. I once got into a discussion many, many years ago when Bert Newborn and I were colleagues at a law firm as to whether Rule 9b of the Federal Rules of Civil Procedure was a violation of the First Amendment. And I think I successfully convinced Bert that we should not advance that argument in our motion. I've never had another First Amendment conversation with Bert that I've won. And I've never dared to have a conversation with Professor Fried on any subject at all. Not when I was a student of his and not since. So here I am as a litigator and now mediator. I'm talking to you about rating agency cases. In the flood of litigation that came after the financial collapse in 2008, there have been literally thousands and thousands of cases that have been brought having to do with the collapse of residential mortgage-backed securities, CDOs, CDSs, and other instruments based on mortgage-backed instruments. And there have been 3 cases to date that I'm aware of, 2 in the federal court, 1 in state court, where rating agencies, which have been swept up into among the group of defendants, have raised issues as to whether or not their ratings of these instruments, which were the necessary predicate for their being issued to investors. And I'm going to leave out for a second the category of investors they were going to be issued to, because that turns out to be, it might turn out to be a significant distinction. But the rating agency has been brought into these cases, and Judge Shinlin in the Southern District of New York, Judge Browning in the District of New Mexico, and a California lower court judge have all found that the First Amendment does allow rating agencies some protection, but not in the context where rating agencies are alleged and or may be proved to have maliciously or falsely engaged in statements that they knew were not true. And Judge Shinlin went on in her opinion to talk about exactly the difference between a rating agency as was traditionally regarded as a former publisher. But in the rating agency cases that are now coming before the court, rating agencies serve not just a publication process, but they also serve as a ratification and a validation of the securities that were being issued. Indeed, it was a condition precedent that the rating agencies give a certain rating before the securities would be marketed or sold. And Judge Shinlin went on to great lengths to, relying on the pleadings, mind you, not the actual proof to date, the pleadings alleged that the rating agencies had received inducements, and the greater the number of securities was sold, the higher their fee, the higher the rating, the higher the fee, and so forth. So she distinguished carefully the fact that rating agencies are entitled to some limited First Amendment protection, but not the across-the-board protection that was being asserted. There's some history on this. In the wake of Enron in 2002, Judge Harmon in Texas issued a very, very lengthy and well-written decision about rating agency protections. And she also made the same distinction that the Supreme Court has made from time to time about this kind of publication. You're not entitled to a blanket exemption. If you engage in false, malicious behavior, and obviously knowingly engage in false and malicious behavior, you're not entitled to First Amendment protection. Fraud is not protected. So although these cases have been conveniently lumped within the corporate free speech, corporate First Amendment panel, my view is I don't really belong in this panel for several reasons, one of which is that these are not the same kind of cases that we've been talking about recently. But I caveat that because as has been made clear, we really don't know where the Supreme Court is going on these kinds of cases, and some of these issues may get to the Supreme Court. We may all be surprised by the way the Supreme Court will treat rating agency claims of First Amendment protection.
Let me ask you this, David. In your view, or in the views expressed in the litigation by the parties or the courts, take XYZ credit rating agency. That's their business. Compare that to a business columnist in the Washington Post or the New York Times or the Wall Street Journal. Is the First Amendment right the same? Are there any differences in that First Amendment right?
Well, I think there are some differences. The business columnist, I think, is a pretty classic First Amendment protection case. The business columnist is pure, pretty much pure opinion, and there's not a commercial motive for the opinion writer to write that editorial or write that piece. In the rating agency situation, they're specifically being paid to do a certain function, and as Judge Shinlin pointed out, the more they do, the more they get paid. And so there's it reminds me of a lot of some of the sovereign immunity cases that arose in the 70s and 80s, where states began to branch out their activities, and when they were sued for their activities, they relied on sovereign immunity defenses, and the court said, no. There was a Court of Appeals case in New York, and there are several cases in Texas, said, no. When you cross the line between being a sovereign and start engaging in commercial enterprises, you lose those protections. And I think the analogy is the same.
Other thoughts?
Well, it seems absolutely right, what was just said. I think that's quite right. Imagine this.
In fact, you argued a great Supreme Court case where you won that, the Boston Port case.
Imagine that what you have is a situation, a commercial transaction, where you can get payment under a letter of credit only if you have a certification from a public weigher that the goods weigh a certain amount. And here the credit agency is like that public weigher, said, yes, this is 10,000 bushels of wheat, and then you get paid on the letter of credit. Well, if in fact it isn't 10,000 bushels of wheat, and the public weigher knew it wasn't, and was paid to say that it was when it wasn't, I mean, he belongs in jail. I mean, that's a clear fraud. Well, this is the same thing. I'm with you all the way.
And the allegations in the complaints do make very strong claims that the rating agencies were aware that the underlying data supporting these RMBSs and other instruments suggested the mortgage default rate could not possibly have been as low as was being represented, or the owner occupancy rate could not possibly have been as high, or that the incomes of the people who were taking out the mortgages could not possibly have been as high as were being represented. And they knew that.
Why are they not complicit in a fraud? I don't get it.
Well, we haven't gotten to the stage of the litigation yet where those findings have been made, but maybe we will.
But the allegations are there.
Yeah, the allegations are there, and the motions to dismiss that are being made are being denied.
But there's another side that's being expressed in the litigation, and I just want to make sure to get that out on the table, as I understand it, which is that despite the allegations that you're talking about, on the basis of the First Amendment, they should be dismissed. Am I right about that?
Yes, and what the judges that have considered the issue today are saying about that is that there may be some conditional support by the First Amendment, but that if the allegations are proved, and there is, we don't have to talk about Iqbal and Twombly in this context, the allegations are proved and the allegations have enough plausibility, then there's enough factual pleading to support the proposition that this is fraudulent activity and not protected activity.
I'm back from 6 months at Stanford. By the way, if the prince is out there who's supposed to kiss me and wake me up, that would be very nice. This was my final exam to my Stanford Con Law class, the CDO cases. And their answers taught me something very important about the case itself. I think it is a harder case than I initially thought. I initially agreed with Charles and David that this was essentially a kind of fraud situation, and if they could prove that the companies, that the rating agencies knew or should have known that that they were publishing false information, then it's not really any different than a newspaper libel case. Or any libel case where someone who knows or should have known that they're publishing false information and you libel somebody, there's no First Amendment defense. The hard question is going to be this. The hard question is going to be a question of proof because the companies, the rating agencies are going to ferociously argue that they honestly believed what they published. And they're going to be able to make a very strong showing that large numbers of respectable people, including people on the Federal Reserve and other responsible economic players, didn't see it coming. They thought this stuff was good as well. I remember, reading an article saying the end of risk. That you were able to slice and dice these CDOs up to so small that the risky stuff would be such a small piece of the parcel that there wouldn't be any more risk. We had gotten rid of risk. And they're going to say, we believed it. We were wrong, but we believed it. Now, the harder issue, the really hard issue in the case, is going to be whether or not if there's a dispute about whether you believed it or didn't believe it, but you're in a conflict of interest situation about what you print, whether we're going to import conflict of interest into the First Amendment. The same way we do malice, recklessness, or knowing dissemination of false information. What about the dissemination of false information in settings where the speaker has a conflict of interest about what to say? When it turns out to be false, are we going to take that conflict of interest as a basis for First Amendment stuff? Those of you who are hiring next year, I will give you the name of the 3 students at Stanford who taught me that in the final exam, but I think they're absolutely right.
One quick comment to that, Bert, is that I think that you're right. There is a potential conflict of interest issue that is arising. But Judge Shinlin made the point that there were 3 elements of the rating agency's role in that particular case that she had before her. One is that the rating agencies were involved in structuring, according to the allegations of the complaint, structuring and issuing the notes, determining how much equity was required at each level. They received a fee that was 3 times their normal fee, and the compensation was contingent, as she said, upon the receipt of the desired ratings.
Yeah.
So, I think the key element to that, her opinion is, she says, unbeknownst to investors.
Yeah.
So we're getting back to the disclosure issue. If the investors knew that the rating agencies were being paid a significant fee, 3 times their normal fee, and had roles A, B, and C, would they have the same confidence in the underlying ratings that were being provided? So I think that is slightly different than a head-on collision of conflict of interest usurping First Amendment issues.
Well, I think that Bert's very clever Stanford students missed an important evidentiary point, which my Harvard students would never have missed. And that is the conflict of interest does not itself wipe out or stand as a substitute for fraud. But surely the conflict of interest may be taken into account as evidence such that the claim that you really believed it would be treated with greater skepticism by a jury. And the idea that conflict of interest is inadmissible evidence would be just laughed away. And as admissible evidence, I would have thought to any jury it would be lethal.
I agree. I agree.
So tell that to you. But,
See, that's
but they've
just
already got their
that's just a
grades,
tip.
so-
No, no, that's just a typical Harvard way.
You put those grades in already?
No, I did. That's just a typical Harvard way of eliding the very important legal issue and putting it onto a fact-based siding where it won't affect society in any meaningful way.
Okay, well, now that we've about that, let's turn to our next topic, which is the last one in this area of corporations raising claims of protected speech. And I'm going to ask Charisse to talk about a couple of important Supreme Court opinions about both indecency, which Bert has already introduced us to on this panel, and about video games. So, Charisse?
So, as I was sitting here listening to Bert, I was thinking, thank God this is my last day at the FCC. So, I think it was good to have all of these cases discussed so that would have a context for kind of the thought process that was going on with the FCC when the indecency cases went up to the Supreme Court. Particularly Fox 2, which I'll talk about a little bit further, but there had been this sense that the corporations were kind of winning when it came to the First Amendment issue. And what did that mean for the FCC's ability to regulate kind of indecent matter, which they had basically had pretty much carte blanche for years and years. And as background, just kind of give you, I think, two cases before the Fox cases that are important. In the Red Lion case, basically, that case stood for the proposition that when it came to kind of a First Amendment standard, in the area of broadcasting, broadcasters receive the most kind of limited First Amendment protection because it was so uniquely pervasive, and it was a medium that really impacted children. And so in those cases, there was going to be a lower standard of scrutiny when it applied to broadcasters. And then in the Pacifica case, which is basically the George Carlin's kind of 7 dirty words case, that was a case that basically said the FCC had the ability to regulate indecent behavior. So all of that as a background for the Fox cases. So the Fox cases basically involved two cases, not the Janet Jackson case, which everybody immediately thinks of, but the first was kind of the Cher case, where Cher went on stage after receiving an award and basically said, now I've also had critics for the last 40 years saying that I was on my way out every year, right? So fuck them. And then the second case, which I think is hilarious because I was actually watching this case at the time, was Nicole Richie after she and Paris Hilton did The Simple Life, and she was on stage accepting an award, and she said, why do they even call it The Simple Life? Have you ever tried to put cow shit in a Prada purse? It's not so fucking simple. And I will tell you, I laughed my behind off at the time, not realizing that 11 years later it was going to bite me in the ass when I'm at the FCC trying to figure out what to do with these cases. So, those cases basically said, so you had this environment, you had the Janet Jackson no nipple case where there was a lot of pressure for the FCC to do something. But the trick here was that the FCC had never really regulated fleeting expletives. So basically, you saw a show and somebody slips in, there's a oops, not this case where he consistently said it. But there was oops. The FCC basically said, that's not what we're here to regulate. We're here to regulate issues, situations where there's a repeated use of the word, there's kind of this sense that you're using it beyond kind of the pale. There's not, the oops situations are just not the ones that we're concerned about. But then after these cases, again, in this kind of political climate where there was a lot of pressure to basically do something, the FCC changed course, and the broadcasters said, absolutely not, we're not going for it. Hence, Fox 1 in front of the Supreme Court. So it went in front of the Second Circuit. And the broadcasters said, first of all, this kind of new change in policy is arbitrary and capricious because they basically changed course without any explanation. And they also clearly violates the First Amendment. The Supreme Court at the time did not, and I call it punt number one, and that'll become relevant later, did not address the First Amendment issues at the time, and basically said, well, we can decide, the issue of whether this is arbitrary and capricious. And what we're going to say here is that, an agency has the ability to change course as long as they explain why they're doing, and the explanation is reasoned, and they have a good rationale here. And, basically we think that the FCC has done both. And so, from our perspective, it's not arbitrary and capricious. So they're fine on that case. And on the First Amendment grounds, we don't want to decide it because we'd rather have a fuller record on the issue, so we're sending it back to the Second Circuit. And then, some of these other cases came up, the Citizens United case, and I think the broadcasters at that time basically said, here's our chance. Here's a clear indication that if we're going to attack the First Amendment challenge, there's really a real hope that the Supreme Court will say the original feeling for a red lion is no longer there. Broadcasting is no longer pervasive now that you have cable, you have satellite, and so the whole reason for kind of the FCC's regulation no longer exists, and thus the kind of First Amendment protections that they've always gotten under this in the situation are no longer there. And so they basically raised the same issues again and included a due process claim that said, well, we didn't have notice because they never told us the policy was going to change. And there was real concern within the FCC about where this was going to go, because there was a feeling that, this might be the time that if the court's going to do something, they might decide to do it. There was also in the Fox 1 case that I just talked about, Justice Thomas at that point specifically said this. He said, this is to note the questionable viability of the two precedents that support the FCC's assertion of constitutional authority to regulate the programming at issue in this case. And he expressed that he was open to reconsideration of redlining and Pacifica. So there was already kind of this thinking that there really might be, the ability of the court to basically say, we're done in these cases. So Fox 2 comes out, and like the day it came out, we were all in our office and we're flipping, and we get to the end and we're like, there's no First Amendment discussion here, seriously? And I think there was somewhat surprise, but definitely on the broadcaster's side, that the court punted again. And the court said, we're not going to even deal with the First Amendment issue. We don't have to. We can deal with this simply on kind of just the due process concern, and we agreed. There was no notice here, and the FCC did not have the ability to initiate the fines that they did, and they basically said not dealing with the First Amendment issue. In fact, there were two sentences where they said, but FCC, if you want to go back and rethink your policy, you can do that, and then at that time we can revisit this again. But, I think this is the one set of cases or one situation where the court hasn't kind of given as much deference to the corporations, and that they've actually allowed the FCC in this case to basically do its job, and they had two bites of the apple to kind of change jurisprudence in this area and decided not to. So that's kind of the indecency cases. Now, when I talked about the Fox 1 case, I said initially there was kind of some angst at the FCC about what the First Amendment case, what the Supreme Court was going to do. But in between Fox 1 and Fox 2, there was the Brown versus Merchants case, which was the California statute. California initiated a statute that basically said you could not sell violent games to minors, and you had to label the games as only over 18. And the Supreme Court basically said this is absolutely unconstitutional. And they said, look, we've said in numerous cases that broadcasting is a unique situation. And I think the FCC at that point said, okay, well, they're actually saying this again. Again, this is before Fox 2. But they said, the indecency cases, the inciting violence cases, those are very different. You cannot initiate a new category of protected of speech by initiating violence as something that basically should have a lower level of scrutiny. And here they basically said because it's not covered, we're going to have a heightened level. We're going to have strict scrutiny here, and you haven't proven that they're proving your case here, because you haven't proven that there's any causal link between the sale of these video games and the violent behavior, and they completely struck the California law down. so I'm trying not to talk too long. But those are the cases kind of in that area.
Anybody have any comments on that?
On the California case, I think most of my life as an ACLU lawyer was spent in arguing against speech regulations on the ground that they would eventually mean that Romeo and Juliet could be prosecuted. I mean, that's what I would go around saying, you know, this statute is too vague or it's overbroad, and if you look at it closely, it would really make Romeo and Juliet into something that you could prosecute. And my nose got a little longer each time I made the argument, but it was a valid argument. In the Brown case, it reached its absolute epitome. The absolute epitome of that argument in the Brown case is Justice Scalia's footnote saying there is no difference between violent video games and reading Dante. That if you read Dante's Inferno, it has an awful lot of really ugly stories about people poking people with pitchforks and throwing them into burning rivers. Gee, I don't understand if we can't, if we let kids read Dante, don't we? And therefore, it carries over that violent video games are the same as Dante. Maybe this is paying for my past sins, but my sense is that borders on the insane. I mean that borders on a kind of cultural suicide that simply says that the First Amendment sentences us to a never-ending downward spiral in the nature of the culture and texture of the culture that we're going to be subjected to, and that there's no stopping point, and that even to children, even to video games, even when there is, and they said, a plausible fear that video games are different, and that when you act out the misogyny or act out the violence, that it imprints it more deeply into your soul than reading Dante, either in the original or translation. And that psychology tells us that there's a difference between images, and the current Supreme Court says that may be right, but you have to demonstrate the same level of certainty about that as about regulating political speech. And that seems to me to hamstring the society. I'm not anxious to license blue noses around the country to come, bring us back to the days when you were worried about Fannie Hill and cases. But it seems to me that the First Amendment can be used as this massive deregulatory device. We've talked about it as a deregulatory device for corporations, but also as a deregulatory device generally. And you really want to ask yourself, if you take the government out by using the First Amendment as a club to essentially get rid of the government, you don't eliminate the regulatory problem. You simply have a kind of vacuum into which private entities, usually driven by profit, will enter in order to participate in an unregulated process. And that's the case whether in commercial speech, and it's also the case in something like Brown. And I think people who care about the First Amendment should be saying to themselves and to everybody else, look, it is not a regulatory pass. It means something much deeper than that. There is an aspirational element to the First Amendment. It is simply not a veto on government regulation. It's the hope for a kind of ideal society that Madison lays out in the Six Ideas. And we should be recommitting ourselves to that and not allow the anti-regulatory folks to simply take the First Amendment over.
But I mean, just to clarify a little bit, I mean, with Brown, and I agree with Scalia's footnote was a little interesting, but part of it was that the software companies brought in a lot of data, basically saying, not only do we not think that there's a link, but all of these, studies that have been done actually show there's not a causal link. And I think it was just going to be very difficult for the state to prove otherwise, because they basically say, well, we believe there's a link, but they didn't have anything on the other side proving differently.
Well, Breyer's dissent. Breyer actually lays out the studies and said, I think they've proved enough to satisfy even the highest burden of proof. So I agree that there was a real dispute about whether or not the causal link was made. But when you're talking about violent video games, it doesn't break my heart to say that the decision about whether enough of a causal link was made is a decision that the people should make, and not the Supreme Court.
When I hear Bert discoursing like this, first of all, I think I'm listening to Warren Berger in Paris against Paris Adult Movie Theater. And then I think, no, I'm listening to Michael Sandel, because Michael Sandel would like to have a Ministry of Culture, which would empower the government's regulatory force to really keep the culture at a proper level. God help us.
Yeah, well, I don't. Obviously, Charles, I think I would be the first one imprisoned under that new regime. But your point is, it's such an important point. The point.
Visit you.
Yeah, I mean, the point is an interesting point, and the point is about lawyers making public policy. Virtually all the cases we make, all the decisions we make, are based upon some sort of slippery slope reasoning, that if we allow this, there's going to be an inevitable slide to that. I've never bought the slippery slope arguments to the extent that many of my colleagues do. I've used them in cases, but I've never really bought many of them. It seems to me that we are capable of making principled decisions about the difference between Michael Sandel's Ministry of Culture, telling us what we can and can't believe and should or shouldn't think, and whether or not California has enough evidence to think that violent video games harm children. I just think that is not beyond the capacity of a democratic of society to make those judgments.
But I don't think you can ignore the fact that there's still, they brought forth no evidence, proving their case, and there's still a situation where violence has not been given the same level of scrutiny as indecency and some of the other things. I don't think you can get around those two facts.
Mm-hmm.
And let me just mention one set of issues that Bert's comments bring up, and then let's move to our last topic, and then we'll open it up for questions and discussion. But one thing that comes up, one topic or set of arguments that comes up in a lot of these cases is that the entities opposing the government statute or regulation say you can have self-regulation by the industries, you can have user tools or consumer tools, and so there's a whole set of issues about that. How important is that argument? Do they work? Who does it? Do you get into other kinds of issues if you've got a sort of self-regulatory body organizing content on the private side? So there's just a whole set of issues, but those do tend to feature prominently in the attacks on the statutes or regulations as part of the argument that there are other alternatives, that there is a way of dealing with these problems so that there's not the vacuum that Bert's talking about.
Well, and I think that would resonate with Charles's idea, and I think it resonates with the fact that the government shouldn't be able to tell you what to do here. The most the government should be able to do is make it clear the nature of what it is that you're about to allow into your home and allow individual consumers to make that judgment. Right. And I think to the extent that that works, that should be the remedy of choice.
Okay, let's move to the last topic, which is when corporations are compelled to deliver or speak a message that they don't want to. At least a couple of cases that have gotten a fair amount of attention recently on this, one of which was mentioned, had to do with tobacco messages in the D.C. Circuit, and there was also a case in the Ninth Circuit upholding a decision striking down a San Francisco ordinance that required sellers of cell phones to include certain warnings about alleged links to brain cancer. So Bert, you want to?
Yeah, and wasn't there a D.C. Circuit case striking down the obligation of employers to provide notice to employees about certain important labor rights? So obviously, this is an area that is now live in terms of litigation. This, as Charles pointed out earlier, this is not about corporate speech. This is about commercial speech. This is about a question of when and under what circumstances can you compel some sort of communication in what is generally an economic or commercial context to allow the consumer, the hearer, to be able to function as a more efficient participant in the economic market. I want to make a bright line distinction, and I think it's a bright line distinction that exists now and will hold. And this is a bright line distinction between compelling somebody to say something in the political arena that they don't believe. The two great cases in our cultural history here are Barnett, where you can't compel somebody to salute the flag, and Woolley versus Maynard, where you can't compel somebody to drive around with a license plate that says "Live free or die." Now, interestingly enough, the plaintiffs in both those cases were Jehovah's Witnesses. So the cases could have been decided as religious freedom cases, but the court chose not to go off on religious freedom. The court chose to go off on free speech. And I think those cases stand for a very important principle, and that's that if we are serious about why we care about free speech, because of the inherent dignity of the individual, forcing an individual to say something that the individual doesn't want to say is probably even worse than preventing an individual from saying something that they want to say. So that the right to remain silent, the right not to speak, is clearly, I think, protected by the political wing of the First Amendment, and I don't see any opposition to it. In fact, I think it is a widely accepted consensus rule. Now, when you roll that over, though, into the commercial area, you get a very different analysis. And it's a very different analysis because I think commercial speech is fundamentally different than political speech, not because it's necessarily less important. I think it may be as important to somebody to know about what a good refrigerator is than to know who's running in the local gerrymandered election that can only go out one way. So that it's not because I think the speech is more important or less important. I think it's that in the commercial arena, the Supreme Court has said over and over again, speakers don't have rights. This is not a speaker-driven phenomenon. It is a hearer-driven phenomenon. It's the phenomenon that Charles was accurately pointing out. This is a First Amendment doctrine driven by the needs of hearers. It's a hearer-dominated First Amendment doctrine, which is why false and misleading speech is not protected. Because if the only reason that you're protecting it is to allow the consumers, the hearers in an economic universe to receive information needed to make rational market choices so that the market will operate more efficiently, if you give them false and misleading information, you're harming the market. You're not benefiting it. Now that's very different than political. And the reason we don't do it in political is when in political speech, you have a Kantian speaker who has a right to say something, even if it's false. And we're willing to tolerate breakdowns of the political market because we respect the Kantian right of the First Amendment speaker. That doesn't travel into the commercial speech doctrine. And that's what the big fight about whether commercial speech is going to change is going to be all about. Whether or not that radical distinction between the two kinds of speech will be sustained. So that leaves me saying that where the government requires a commercial speaker in a commercial context to make information available to consumers that is reasonably needed to allow the consumers to make a rational market decision. And that's labeling, ordinary warnings, much of the securities markets, the limitations of speech in the securities markets. Those are all, I think, safe and immune from serious attack. But when regulatory agencies go beyond that, and they try to use the compelled speech as a kind of, as a mechanism to induce consumers not to buy the product, either to frighten them out of buying the product or to in some way alter their marketing decisions, not through giving them information, but by being a motivator. I think at that point, you've crossed the line about, and I think that's where the courts now are zeroing in. It's one thing to require tobacco, cigarette companies to notify people on the packet about the terrible aspects of advertising, and to make those disclosures in connection with advertising generally. It's another thing to take up 3/4 of the cigarette pack, and to essentially turn the cigarette pack into a anti-smoking ad. There, what you've done is you've crossed over from the legitimate purpose of the compelled speech in a corporate commercial area, and turned it over into making the corporation or making the speaker into the billboard for the government speech. And there, I think the line will be held. That will be declared unconstitutional, but the informational stuff will continue to be protected. And I think it's important for people who care about this to defend that line. Because if we allow the line to creep to the point where compelled speech is essentially just the government urging people not to buy the product, we're going to lose the whole compelled speech doctrine. And so it seems to me that we have to back up and say, no, no, no. Compelled speech is okay when it is linked to efficient market choices. It's not okay when it's a form of propaganda.
But how do you draw that line? I mean, is it text versus graphic images?
No, no, no.
I mean, of the package
sure.
versus 2/3.
Well, I mean, obviously, line drawing is not going to be easy in this area. But I think the question is the government. I think the government has the burden of establishing why the particular form of speech that they have chosen to require the speaker to carry is necessary to permit a genuine rational market choice. And if there are other narrower ways that they could have done it, then I think they should do it that way. So they'll win the graphic versus the speech, because graphic is a better way of communicating. But they won't win the graphic if it takes up 2/3 of the packet. I suspect that's the way the line is going to be drawn, and it's a line I think that we can live with.
Okay, let me open it up at this point if people have questions.
Okay.
Yeah, it was the first hand.
So I've been hearing that internet service providers are trying to use forced speech doctrine in the corporate, and this is in the corporate, I believe, not commercial context, saying that they shouldn't be forced to care, that they should be allowed to censor certain kinds of speech that they carry because it violates their corporate speech rights to have to carry that. I wonder if, whether it's Sharice or somebody else who's been hearing about this FCC kind of this communication.
Well, that's a very important, interesting case because it makes the distinction between the internet service provider as a common carrier, and the telephone companies have been under that common carrier obligation since the beginning of telephone companies. And the internet service providers can't easily fit under that rubric, and they don't want to fit under that rubric. They want to be First Amendment publishers. And in order to be that, they've got to publish some content. And many of them do. And that's how they get that protection. But if they are simply a pipe, they don't get First Amendment protection, like the phone company doesn't.
This is the Title I, Title II distinction.
Like the trolley car company is not responsible for what you do when you get to your destination. They just carry you there.
Yeah, that court case hasn't been heard yet. It should be heard at the end of the year and decided then.
But it's interesting because in other contexts, the Communications Decency Act, for example, says that a service provider is not liable for content provided by another, which a newspaper is. If it publishes a letter to the editor and if it's defamatory, the newspaper is liable. And so, and the argument there is, we can't possibly know, all the content that's there, and it's explicitly, we're not a publisher. So it's interesting how the sort of cross currents on that. But, Walter?
Yeah, returning to Citizens United, Professor Fried, the way you set up the question, it seems to me, at least in my view, has within it the grounds for objecting to your conclusion, in that you recognize the potential rights of dissenting shareholders and recognize that the corporation is an association of people who have not joined together necessarily out of political purposes and may vary on that. And in that, with that recognition, why is not the simultaneous restriction or prohibition of corporate political speech, but the protection of the ability of the association of people within the corporation to, as individuals, not using the accounts of the corporation which have been amassed for a certain purpose, but using their own money to further the economic interest or other interests they see aligned with their corporate interests, as in a PAC. So if you have a system in which you can conceive of political regulation, not as a restriction on speech, but as a restriction on which account you go to pay for the speech. Do you go to the account that has been amassed by people for a different purpose, including people who choose to invest for economic purposes but do not share the corporation's politics, or do you form your own account out of the association, having the advantages of associating as a corporation, but giving people an opt-in to do that? And with
that's what we do with labor unions.
Well, but why isn't the PAC regulations in essence conceivable as that? And the prohibitions that were overturned in Citizens United, why can't they be conceived simply as a means of prohibiting the use of collectivized accounts for different purposes for political purposes?
Well, I couldn't agree with you more, but I think that your point is a more general point. I think if you track the areas in which we give corporations constitutional rights and areas where we don't give corporations constitutional rights, you will find that the areas where we give them constitutional rights is where there's a consensus among the human beings who make up the corporate community that this would be a good thing to do. So they're citizens for the purposes of litigating in diversity. They have property protections to allow them to operate their businesses. The only two places where I think this shouldn't happen is the Fifth Amendment, where there is a clear conflict of interest within the corporate community about whether to allow management to prevent the shareholders from learning about potential criminal activity, and electoral speech, where the conflict within the corporate community is so great that we shouldn't allow the corporate management to use other people's money to advance their particular ends. And those are the two areas where I think that we should say no to corporate constitutional rights and insist upon treating what it really is, which is a collective of individuals put together to perform an economic function. So I think I would take your point even further than you took it and use it as a general theory for when corporations have constitutional rights.
Yes. I wonder, questions directed to the question before, where in the compelled speech doctrine, where you would place certain laws that require doctors before abortion care to, read a little speech to the patient, or saying something that maybe they don't even believe as a doctor or think is medically incorrect, where that lies in the political versus commercial speech area.
Well, maybe this is my politics, but I don't have any trouble striking that down. But I think that there's a distinction. There's a distinction. You could require the doctor to provide accurate information to the patient on mortality rates, and that wouldn't bother me one bit. That would allow a patient to make, but you can't require the doctor to turn himself into a propaganda mill for the state and try to talk the woman out of the abortion. And that's the line I'm trying to make, a line between providing information to a consumer needed to allow the consumer to make a rational choice and drafting somebody to be a billboard for the state and forcing them to then say things that will manipulate the behavior of the individual to whom the speech is carried. So I should have thought of that as the best example of my line.
I think we have time for one more question. Yes?
Well, I don't know if this is really a question, but going back to the Sorrell case and Professor Newborn's observation about RAV, I mean, I think your earlier comments illustrate why I think that may be problematic. That is, if we're going to, the Sorrell case talked about discriminating against marketing. And if you talk about discriminating against marketing, that really makes a nonsense out of the commercial speech doctrine, which is a content-based restriction, right? The restriction of different treatment on the basis of its marketing content. And analogizing that to a political thing like RAV, I think is potentially a category mistake. That is, we have difficulty then regulating marketing if we're going to treat marketing like an opinion. If that treats running a business like an expressive activity, and it says, you know, any business I run is really a First Amendment activity, it's expressive. And, you know, this is why I think the Coronia decisions, reversing that fellow's conviction under the off-label use marketing. I mean, the FDA makes a category, a content restriction on the pharmaceutical companies regulating off-label use marketing. And that seems to me, I think it's a bad result, but I think under the current law, now that's unconstitutional. And that's a problem.
Yeah, I think if I, understand your comment correctly, that the Vermont legislature was exactly making a decision about, in the interests of public health and safety, there's a difference between what academic researchers are going to do with this information as opposed to pharmaceutical marketers. And they made a decision based on the record before them and their fact-finding that the pharmaceutical marketers would have a much different impact on the doctor-patient relationship, would harass doctors in a way that academic researchers wouldn't. And so, I think we talked a little bit about line drawing in other contexts, and I think, again, that's where the line was drawn by the Vermont legislature. They had a reason for discriminating or treating differently those two different people who would use the information.
Great. Well, that is all we have time for. Thank you to all of you, and thank you to the panel.